Welcome back. With us now is Bruce Ralston. We're talking about tax debts in bankruptcy. Bruce, we've gotten into the whole thing of what makes a tax debt dischargeable in this, but there's some exceptions to that. What are those?
Let's see, where do we start? Well, first, I want to bring up something else real quick here.
Sure.
During the break we were talking, and I should point out that I am not a tax preparer. I don't do taxes. I don't do my own taxes. Okay, don't ask me tax questions. But what you pointed out was that quite often it's the bankruptcy lawyers who know this one thing and the accountants who don't. And so we need to communicate with each other. That's a good point. But the different exceptions, there are things that can break up this pattern that I just described. So even if you, in the vast majority of cases, if it's a personal income tax and the tax returns were first due to be filed 3 years ago and it was actually filed at least 2 years ago and there has been no recent assessment, then it's just going to be a general unsecured debt, which will be discharged in Chapter 7 or treated, they're at the end of the line in Chapter 13. Everything else gets paid before they do. But there are things that can change that. There are, or in exceptions, I should say, if there is fraud or willful evasion, and fraud is pretty high standard, and it's actually the IRS's burden to prove fraud. They don't usually do that unless they've got a real perp walk kind of case. They're not going to do that because all they have to do is claim willful evasion, and that's a much lower standard, and it becomes the consumers, the taxpayers' burden to prove that they did not willfully evade this tax. So what is willful evasion? Very long list of case law, but what it boils down to is mere failure to file returns is not willful evasion, but just about anything in combination that will be. If you're in a tax protest group and you don't file your returns, you're willful evading. There was a pretty well-known case where this lady was at home with the babies and her husband was gone, and the revenue officer came and knocked on the door and said, "I need to talk to you about your tax debt." And she said, "No, come back later when my husband's here." That was deemed willful evasion. She didn't know the guy, but the judge said, "You should have let him in, you should have talked to him." There are also tolling events, and there are a number of tolling events, some in the bankruptcy code, some in the IRS regs, and a lot of those I don't even know. But the biggies are bankruptcy. Okay, if you had filed a previous bankruptcy, then when that 3-year period is running, when the clock has started ticking and you go a year and a half and you file bankruptcy, boom, the clock stops. And however long that bankruptcy lasts, the clock is staying still. And then after that bankruptcy is over, you wait 90 more days, and then the clock starts running again. So you can revive that, but if there's a bankruptcy, then that would toll the running of that time limit. Tax court actions. If you actually bring something up in tax court, then that can toll the statute of limitations. An offer in compromise will toll the statute, not the statute of limitations, but the running of the 3-year period. Interestingly, regular IRS installment payment agreements do not toll anything. So you're always safe just setting up a voluntary payment plan. But anything else might keep one of those clocks from running. And again, you have to look at the tax transcript, the account transcript, to get this information.
We need to be clear that those are the time clocks for the discharge of it in bankruptcy. If we're talking about time clocks in regards to IRS collections and what's in the IRC code, those are different.
Completely different, different, yes. Now, there are some things that from the IRS on their own internal regulations that do bleed over into the real world, and if you can consider bankruptcy land the real world. But for instance, there's a 10-year collection period. Once and 10 years starts from the date of assessment, if I understand that correctly.
Right.
So once the tax was assessed, if you can look at this account transcript, or sometimes if they've registered a lien, all the information will be right there in the public records, and you count 10 years from that date of assessment. And if 10 years has passed, and if they haven't renewed their lien, then they're probably not going to do anything. And sometimes you can tell people just sit and wait and do nothing. And especially if you're being treated as uncollectible anyway, then eventually they do go away. And like I say, the IRS can be very practical in some ways.
Yeah.
Tax liens. We discussed that earlier, tax lien, and you described it exactly right. There's a statutory lien, the secret lien that is imposed as soon as they assess, but you don't pay right about that time period. But that usually doesn't really mean anything. And everybody who does bankruptcy knows that once you file the bankruptcy, then no new liens can be registered. And that applies to the IRS as well. So if you file the bankruptcy today and they register their lien tomorrow, they're out of luck. It's void. It doesn't exist, and it's treated just like everything else. But once they do have a lien imposed, then these rules become all overlapping, and it's like a evil artichoke, and you have to really peel away these layers and think about things in a different way, and individually point these things out, and it's still quite often just impossible to lay out. Another thing about tax liens. Every state has their own rules about how liens are imposed. In Tennessee, a lien, or this kind of lien, has to be registered in the county. And one of my favorite stories has to do with my client who lived, his address was Collierville. His zip code was 38017. He lived just across the county line in Fayette County. He had everything appeared, I mean, if you just glanced at anything, he lived in Shelby County, but he didn't. And the IRS filed a lien in Shelby County. And he owed $250,000 in taxes, and it's, I don't want to take total credit for this. He had actually figured all this out before he came to me, but he came and said, "Is all this true? I've read this. Is that right? Is that right? Is that right?" Sure enough, we filed the Chapter 7, and $250,000 tax debt gone because they didn't register in Fayette County.
Yeah, so it wasn't a properly secured debt.
Right.
Yeah.
The imperfected security lien, and that worked. Of course, he probably didn't have that much stuff that the lien would have attached to anyway, but still.
What happens with the tax debt if it was properly secured?
It passes through just like any other secured debt would. And just for an example, let's say they register a lien for $100,000, but this person only has $10,000 worth of assets that have any value, and if assuming all the other tests are passed, then you come out of it, and all the other $90,000 is gone, but you still owe the $10,000, and they will try to collect on that.
Okay. Well, our time is up for this edition of Legalese. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. You can also follow us on Facebook and Twitter. And if you have any questions about taxes and bankruptcy, you can reach Bruce at MemphisBankruptcyLawyer.com. So please join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.